and they agreed to come again. We didn't scare them off last time. But what we're going to do today is we're going to take a deeper dive. You answer questions and just kind of dive into no silly questions, and there's stuff we'll all learn from, not these guys, they know it all, but stuff that we'll all learn from today. So make sure you ask questions. When you do, we are going to video it today. So Jenna's our runner, and so when you guys have a question, raise your hand. We want to get to you. We want to put a mic right up to you, and then so we'll be able to share this. There was people that reached out to us that couldn't be here today, so we just want to help the masses. So like I say, we'll just go ahead and get started then. And like, again, what John said here, just because you make plans or the estate plan, I feel really tall. Just because you make that, do the estate planning and everything, doesn't mean that you think that you're going to die. That's not the point. The point is to get your ducks in a row, and you can see Andy put, all right, who messed up their ducks up here? Take a duck with you, and that will remind you guys to get your ducks in a row. So I'm going to go ahead and turn it over to you, John.
All right, thanks, Jane. John Lander, I'm an attorney here in Mason City. I've been practicing since 1995. This is my son, Jack. He joined me in April of last year, but he's been working at the office for a number of years before that. So we're here to talk about estate planning. Last year when we talked about kind of the bigger picture, which was there are a number of different ways to transfer your property. You can transfer your property while you're alive, and you would do that by adding somebody to a deed where you own property maybe as joint tenants, or you want to put your child on your deed so that you think you can avoid probate or something like that. So the way you own property is one way that property gets transferred. It can either happen while you're alive or when you pass away. Another way that property can transfer is through probate. And so that's like your standard will, where maybe you have everything to your spouse, and if your spouse fails to survive, then it goes to equal shares to your children or something like that. In order for property to pass through a will, it's got to go through the probate process, which is really just a court process. The problem with that is there are fees. You're going to pay me, and you're going to pay the courthouse. And we want to try and avoid that if we can. And then the third way that we can transfer property is through a trust. So those are really kind of the three different ways that we can transfer property. And there are pros and cons in each one of those paths. And we'll dive deeper into each of those. I could talk for 3 or 4 days probably about this stuff. So I'm interested in your questions. If you have questions at any point in time, please raise your hand and let me know, and we'll try and address it. I think people are afraid to come to me for a couple of reasons. I think one reason that people this is just me speculating, I charge by the hour. So I think people are trying to avoid that if they can, and I get it. And so if we can answer some questions that maybe might help you with some planning without having to come see an attorney, that's great. I think ultimately what you'll probably conclude is it might be worth spending a little bit of money to come talk to me or another attorney to make sure that your plan is what it should be. And then the other reason I think people don't come to me is that they don't want to think about death. I'm 55. As I get older and as I do more of this work and I see more people pass away, it starts to remind me that I'm not going to make it off this earth alive either, and that can be depressing to think about. But what I found is that once you get the estate plan done and behind you, at least that first part of your estate plan behind you, then you can stop thinking about it, and then it's just a matter of updating your plan as things in your life change. And then I think another problem is sometimes people have a difficult time making decisions, and I can help you with some of that. I can't make the decisions for you, but I can give you ideas of different ways that you might want to dispose of your property at your passing and what the repercussions of that are. So I think those are really the primary reasons that people don't want to come to me. So what I would tell you about that is it isn't about end of life. It's about protecting your wishes and your dignity. if somebody hasn't planned for their passing, then I usually end up seeing the beneficiaries after somebody has passed away, and that's when the fighting might occur. And I think that if it were my estate and I had passed away and I was in heaven looking down and my family was fighting over my assets, that would not make me very happy. So I would be interested in getting my estate ducks in a row before I passed away so that there really wouldn't even be the opportunity for people to argue about it. So that's some incentive to get it done now.
Isn't it true though, John? I just want to reiterate something here, but we don't have to be seniors, because if you have kids, if you have assets, if you have anything, I mean, whether you're in your 30s, your 40s, your 50s, you have to plan for it, because we aren't promised tomorrow, right?
You're right. And Jack, I think his first task when he started his job as an attorney was for him to draft his own will and his own power of attorney documents. And it isn't just about wills. So wills, that's what happens when you pass away, or a trust, but there's also power of attorney documents. And so power of attorney documents are those documents that are in place while we're alive to give authority to people to deal with our finances or our medical issues when we can't, or when we're not available to do things like that. So even, it isn't just about a will. And I'll tell you this too, I find that when people come to talk with me, especially if they've never had an estate plan, I think they end up learning more about the process and what they can and should be doing with their assets, even outside of the will. So the whole goal for me when I see a married couple, for example, is I don't want the surviving spouse to have to go through probate at the passing of the first. Because then we end up with two probates, because ultimately the second one's going to pass as well. So we have two probates, we have two probate fees, we have two sets of court costs. In almost every situation, if not all situations, I can make sure that your property is held in a way that at the passing of the first, we don't have to probate. And you'd be surprised at the number of times that I've met with somebody and my staff will get their real estate records and we find that there's a piece of property that is in one of the spouse's name only.
And I'll add to that, it's really easy to do that on accident. It's really common. For example, I bought my house before I got married, and then I got married like 3 months ago. We still haven't put her name on the house yet. So if anything happened to me right now, that house is in my name only. And I know all these things, and I know to keep that in my mind. But there's plenty of people who bought their house and they got married, 60 years passes, we never thought about it. Now all of a sudden we're in our 80s and that house is only in one person's name. We didn't know that the whole time.
Or maybe their house is 2 or 3 parcels and they didn't realize it. And maybe the attorney that was doing the transfer documents missed a parcel. We've had that happen. And we've had situations where we have a husband who had property, bought the property, it was in multiple parcels, got married, transferred the asset into the wife's name as well, joint tenants with rights of survivorship, so that when the first one passes, it goes to the survivor by operational law. There's a couple things we have to do, but no probate. Come to find out that one parcel wasn't included. Well, to make matters worse, he didn't have a will, and he had children from a prior marriage. The house that she was living in, there's a piece of property that's next to it that has an additional dwelling. She had to pay her stepchildren. She had to buy her stepchildren out of that parcel of land because without a will and children from a prior marriage, it doesn't all go to the surviving spouse. It goes half to the surviving spouse and half to the children of that first marriage, which all could have been avoided, not even with just a will. If they would have just come talk to me, I would have discovered that there was a piece of property that was not in both their names as joint tenants, and we could have solved that problem. The other thing is payable on death beneficiary designations. There's all sorts of ways to transfer assets by way of beneficiary designations that don't even have anything to do with a will. So we can learn a lot about that just by talking with an attorney, assuming that the attorney goes out and does a little bit of homework first. Reduces stress, conflict, cost. So just that scenario that I just discussed probably cost her $60,000, $70,000 that she wouldn't have had to have paid. And she wouldn't have had to have paid either if her stepchildren would have been decent about it, but of course they weren't. So there was a lot of expense that she had to go through. And it makes things easier for your loved ones. Yeah, go ahead.
We had an email come in today that they couldn't be here, and her spouse has passed, just recently passed. Is it important to remove the spouse's name from the deed?
Yeah, so it is. So you have one piece of property and it's owned as joint tenants with rights of survivorship. So that's when I talked about those 3 avenues for disposing of property. One is ownership. So that's a way that you dispose of property by ownership. You own it as joint tenants with rights of survivorship with your spouse. They pass away. So this is what happens apparently. Some people, the surviving spouse, will call their attorney and say, my wife just passed away. The property is joint tenants with rights of survivorship. All the balance of the assets are in my name. Do I need to do anything? And for whatever reason, the attorney says no. There are some things you need to do. If there's an original will, you need to file it with the clerk and publish notice for 4 consecutive weeks, or
Months.
2 consecutive weeks for a 4-month period is a creditor period. Then after that, all the creditor claims are cut off. But what we do also, in addition to filing the will, is we file an affidavit of surviving spouse with a recorder's office that says that that person has passed away. That document gets picked up in the abstract. Are you guys familiar with abstracts? So I've got one here I got to take home tonight. So this abstract is full of all the documents related to your real estate, and the recorder, they have them on record, and then the abstract company puts them and binds them into this document. Well, when somebody goes to sell when you go to sell your property, so let's say I'm married, my spouse passes away, we own it as joint tenants with rights of survivorship. If I don't file that affidavit and then I go to sell the property, the attorney for the buyer is going to say the title is not clean because it's still owned by somebody else that's not the seller. And what they don't know is that that person has passed away. So we record an affidavit that shows the attorney that's representing the buyer that that person has passed away, so that I'm the only person that has legal title, so that I can sign the transfer document and transfer that property to the new owner. So yes, something has to be done.
And when, I guess her next question was, when do you get the attorney involved? As soon as possible, especially for the creditors?
I think what she asked is, do we need an attorney?
Does an attorney get involved in doing this? Yes, you're right.
Yeah, so, yeah, I don't think you can just go up to the recorder's office and say, I need a surviving spouse affidavit. I think there was a time, maybe 30 years ago, because I've seen some form documents where it looks like maybe the recorder's office was just kind of handing those out to people. But nowadays, you do need an attorney. It's like $150 to prepare an affidavit for surviving spouse. It's not a lot of money. You could do it on your own, but you'd have to know what you're doing. Well, it's very detail-oriented. We have to make sure that those legal descriptions exactly match. There's some realtors in here, and you know what I'm talking about. Yeah. What planning can accomplish? Choose your decision makers if you can act. So we're talking about a financial power of attorney and a medical power of attorney. If you're not able to make your own financial decisions, if you're married and your spouse is on that account, they can handle the banking. But they only have access to assets that are jointly owned. If it's an asset that isn't jointly owned, they're not going to have the ability to do that. There can be other reasons. So for example, Medicaid's a big issue too. I often get the question, how do I protect my assets from the nursing home? You're not protecting your assets from the nursing home. You have to pay. You have to pay to be at the nursing home. And when you run out of money, then Medicaid will pick up the bill. But the idea is, how do I get Medicaid to pay for my bill when I still have a spouse and we still have assets? I'm not going to get too deep into the weeds there, but if you transfer all your assets to your spouse, and then your spouse spends some of that down, you could qualify for Medicaid. So the example I typically give to people is, let's say Jane and I are married, and I am in a car accident and I suffer a head injury, and I have to go into long-term care. Jane, as my spouse, has some options. One option is she can use the family resources to pay for my care. But if she does that, ultimately she's probably going to run out of money because it's expensive, right? There's another option. If we have long-term care insurance, we can use that to pay for it, but most people don't have it, and even if they do, it's not going to probably pick up the full bill. And then the third option is we can transfer all of the assets out of my name as Jane's spouse to her, and then I'll qualify for Medicaid with some variations there. But if I've suffered a head injury, I can't release my interest in my property. Even if we have, like, just say a house that we own together, I still own that house. I'm in long-term care. Medicaid won't pay the bill because I have an asset. Connie's probably familiar with some of this stuff, with some exceptions. So how do we get the asset out of my name into Jane's name? Well, the only way we can do that is if we have a valid financial power of attorney, and if that power of attorney gives Jane the ability to gift my property to herself. So that's what a power of attorney can do for you, is give us the ability to allow a spouse that's going into a nursing home to transfer their assets to the community spouse so that the community spouse can use those resources to live off of. But it isn't a free lunch. When we're both gone, whatever's left, if Medicaid has paid, they're entitled to reimbursement up to the limit of their claim. None of your beneficiaries are responsible, so if there isn't any money or there isn't enough money, they're not going to have to come up with that. But that's one way we have somebody who's authorized as our agent to make financial decisions. Medical is another issue. So the medical power of attorney is effective on a finding of incapacity. So until I'm not able to make my own decisions, I make my own decisions. But when there comes a point in time that I'm no longer able to make my medical decisions, who's going to make your medical decisions for you? You can choose that by completing a medical power of attorney. And you can name the person and you can name an alternate. But if you don't have that, or you don't have the financial power of attorney, then the process that people have to go through in order for those decisions to be made is a conservatorship and a guardianship, which is a court proceeding. It's expensive. There are annual reporting requirements, and we don't really want to do that if we don't have to.
Should probably always have an alternate, shouldn't you? I mean, because it's...
Yeah, and that's the other reason, like when we talk about if your spouse is your primary agent, if they're the person you're named as your financial or medical power of attorney, and they pass away, should I go to an attorney? Not only should you go to attorney because we have to file that original will, not only should you go to the attorney because we need to file that affidavit to change title, but now your estate plan documents probably need to be updated. Because I'm guessing that your spouse is probably your executor. Your spouse is probably your primary medical power of attorney agent and probably your financial. And hopefully you had a backup, but now we need to move that backup into the primary position and we need to get another backup. Does that make sense? Okay.
I have a question.
Okay,
Oh,
here comes Jenna.
When you talk about wills, my will was, mine and my husband's will were done in Minnesota. So I contacted the lawyer that we went through about that and asked him, you know, could he do this with the recorder in Iowa
Do what?
to get my name on the, take his name off of the house and put my name, just have my name on it.
The property was here in Iowa?
Yeah, it's here
Okay.
in Clear Lake. And so he kind of hesitated and said he didn't think that Minnesota would let him do that for Iowa. But, so I contacted a lawyer here in Clear Lake, but I haven't talked to him yet. will that will be accepted here?
Okay, I'm going to need to ask you a couple of questions. So, your husband passed away.
Yes.
The will will be accepted. We accept wills from whatever state they're in, and we can file them. The question is whether or not we really need to. So the analysis would be, did you own all of your property as joint tenants with your spouse? And if you did, if you have an original Minnesota will, I would record it with the clerk of court. I would publish it for 2 consecutive weeks, and we'd wait that 4-month creditor period, and then everything would be done with that. And then we would file an affidavit identifying that your husband passed, and we would record that with a recorder, and that would transfer title to you. So that's the process that we'd need to go through. There wouldn't be any formal probate if everything was in your name or payable on death to you, or you owned it jointly with him.
The reason that attorney couldn't help you probably
Yeah.
is because that attorney's licensed in Minnesota,
Right.
not in Iowa.
Yeah.
So for example, whenever we do any work for people up in Minnesota, say someone has a house here and they have a house up there, if we're going to do anything with that house, we reach out to an attorney in Minnesota because we're not licensed there, and we just have them help us with that one part and we do the rest.
Yeah, and we get similar sort of contact where there are attorneys in Minnesota, their clients are in Minnesota, but they have property in Iowa, and they're asking us to help them with just the transfer documents. Now, I don't think I'm actually required to be licensed in the state of Minnesota to do the transfer document, but I understand how Iowa rules work with respect to property, and every state's a little bit different. So I really wouldn't want to be messing around with Minnesota property, and I'm guessing that attorney feels the same about Iowa property. Because not every state uses abstracts anymore, so that they've got different processes up there. So it's probably not so much that he couldn't, he or she thought it would be a better idea if they didn't, and that you'd be better represented if you had an Iowa attorney.
I think the biggest takeaway here, and what I'm hearing is, which, I may or may not have known, is that step of the creditors is to putting that out there and to transfer title, because I think, you think we own it jointly, so everything passed to me, and then that stops. So I think that it's probably a misconception that, that you don't need to kind of keep going or contact an attorney and do
Like
all
the
that.
property, the property doesn't just transfer to you. No different than if you have a bank account and you own it jointly with your spouse and your spouse passes away. They don't just automatically transfer it to you. You have to provide them a death certificate for them to do that,
Yes.
right?
I went through that, and it happened that they sent my income tax papers by e-statement. So I went into the bank account to get them, and I couldn't get into the bank, into that part of the bank. So I called them, and they said, well, it's in your husband's name. And I says, it's a joint account. We've had it for over 20 years. Well, he's the primary person. Now, when you take out a bank account, they don't tell you that.
So one of the things we also do at our appointments is when I'm going through an interview sheet, I'm asking about your assets. And so I say, okay, tell me where your checking account's at. Well, it's at First Citizens Bank. I say, well, how's it owned? Oh, well, I don't know. Or I think it's owned jointly, or it's just in my name. Well, if it's just in your name, we've got to get somebody either on there as a joint owner, or we have to have them on there as a payable on death beneficiary. Otherwise, we're going to end up in probate at the death of the first. There are some exceptions to that, too. If it's below $50,000, we can get to it with a different tool, but your attorney would help you with that.
I was on there jointly.
As long as we can prove
But I
it.
still couldn't get into that part of the bank.
Yep.
So I had to fill out 4 pages of
Yep.
stuff just to do that.
Yep. Yeah.
Does it make a difference?
Hold on one second. Let's get the mic to you.
When you own property or your car or anything, does it make a difference with your 2 names on? Now, we're Dave and Carrie. Does it make a difference if you have "and"
Or? So,
Or and or?
yeah.
Good
We're-
question.
Yeah, we're lucky because, well, if you live in Sarasota County, we're lucky. Because the recorders or the treasurer's office differ from county to county. And in our county makes it very easy to transfer that vehicle, even if it's just in your name. So if we've done everything the way that we're supposed to as far as property ownership, but oops, we forgot to transfer our vehicle and make it or is the best. That's the answer to your question, or. But if you don't have it or, if you have it and, or if you just have your name on it and you're the one that passes away, Sarasota County, all you got to do is bring in the death certificate and the will, and they'll transfer the title. But you won't find that in every county. So the best way is or. What I usually tell my clients is, you don't have to, if they just have one vehicle, go make the fix. But if you have 15 vehicles, I probably wouldn't go do that. But as you're moving forward in life, when you do buy vehicles, make it or. Husband or wife. Yeah.
Oh, yeah.
Janet, you don't have to go to the gym tonight.
Thank you. Getting back to a Medicaid issue for a second, if there's no spouse and no offspring, there's still a mortgage on the house, which is the primary asset, and Medicaid long-term care is required ultimately. Can Medicaid then put a lien on the property or force a sale to recoup any of the expenses that Medicaid has paid out for that care
You talking about after you've passed?
after you passed?
Yes.
Well, actually, either way, before or after.
Well, I'm not sure I'll be able to answer the before, but the after, if you pass, now we have a piece of real estate. A piece of real estate can't be transferred unless there's an executor or an administrator. So in order for us to sell that property, an estate's going to have to be opened.
Or even to transfer it anywhere else. Something's going to have to be done with it, so we're going to have to open an estate to do whatever that is.
So, I'll just give you a couple of examples. For some reason, Capital Mortgage has been, I've got 5 or 6 cases with Capital Mortgage, and what's happened is they loaned money to the homeowner. The homeowner died. It's upside down, and that would be no different than if we had a mortgage or a Medicaid lien. It's upside down. No one's going to make any money off of this. So the lineal descendants are like, I'm not interested in getting involved in this. So now I've got a mortgage holder who has a piece of property as a creditor, and they want to see that property sold. Medicaid would be the same. They would be a creditor. And so what Capital One has done, Capital Mortgage has done, or Medicaid could do, is they would open an estate as your creditor. And then they would have the property sold, and then they would recoup their money off of whatever lien they had against the property.
And that's regardless of whether or not it's been named in a...
Doesn't matter, because Medicaid takes priority.
Yeah,
Medicaid takes priority and the mortgage takes priority. Well, Connie, so if they're alive, if they're alive and they're in a nursing home and they're on Medicaid, there has to be some sort of, in order for that to occur, there has to be a physician that says there's some expectation that they're going to return home. Otherwise, that property has to be listed for sale, doesn't it? Or do you know?
Yeah, I thought the house and the vehicle is kind of a pass on that, but it's really the resources, but that's.
So they'll let you apply for Medicaid and
Yeah.
receive Medicaid even if there is a house?
One house, one vehicle, and then it's, more about the resources. But
And they'll pay for long-term care?
that's my understanding, but
Yeah,
check it out, so, yeah.
I would defer to you, but I do think that there has to be some expectation that they're going to return to home. Otherwise, they'll make you list it. And they'll pay for the bill until the house is sold. And then, right?
Right on.
Yeah, then you have to deplete those resources down, and then you're back on Medicaid.
Spend it down.
So, as long as there's no spouse living in the house. If there's a spouse living in the house, then there's an exemption that's available for that. So long and short, Medicaid will get whatever they want.
I just wanted to know, what are the negatives of putting a child on your deed?
Well, if it's my child, there's no negative.
That's not true. We sit through appointments every day, and
Yeah.
he says,
Oh, yeah, it's an awful idea. It's an awful idea. So I think one of the reasons we're seeing kind of an uptake in estate planning is all of the information that's going around social media. And one of those theories is you can avoid probate by giving your house, putting your child's name on your house. So there are two ways that can happen, neither of which is a good idea. One way is I could give my house to Jack right now. And if I give my house to Jack right now, then he has it. In theory, I'm a tenant. If he ever gets to a point where he's unhappy with me, he can evict me. And we've seen it, so we know what happens.
I've done one and only one eviction at our office, and it
that
was
was
a
it.
child evicting their parent.
Second part of that, which applies to the other scenarios as well, is it's a basis issue. It's a capital gains issue. So right now, if it's my residence and I go and sell it, so I paid $175,000 for my house, and I think they say it's worth $340,000 now, whatever. But if I sell it, it's my primary residence. So as a married couple, I get $400,000 of actual capital gain exclusion. So profit, I have to profit more than $400,000 before I have to pay capital gains on my primary residence. But if I give it to Jack and he sells it at my death, or even while I'm alive, if I say, hey, I'm going to go get a condo now and you can just sell my house, he has to recognize the capital gains on the difference in sale.
Because I get your basis.
He inherits my basis. When it's a gift, he takes my basis, so it's $175. So if he's sold it at $350, he's going to have to pay capital gains on $175,000. One of the benefits of property passing either through an estate or through a trust is it gets that step up in basis, so you revalue the property at my death. And so if I kept it and passed it to him at my death, then he can have the property appraised or sell it at my death, and whatever the sales price is, that's the new basis. So if your sales price and your basis equal the same, there's no capital gains, right? So that's one detriment of putting your child on it now. If we put his name on it now and my name isn't on it at all, then it's subject to rental inspections. So that's another downside that people don't realize until it happens. It's also subject to the claims of his creditors. So, and it doesn't have to be any creditors that he has at this moment. If I pass the property to him and he gets in a car accident, if he kills somebody and the damages exceed the value of his limits of liability, that's now a judgment against my property. And it's not entitled to creditor protection. So if the injured party sues him, they can take that asset.
They couldn't get my house because I have homestead protection in my house, but my second house
They can.
is not protected.
So that's if you give it all to them. If you just put them on there as joint tenants, it's the same. Well, I guess there's one other issue too, gift tax. So we're all entitled to give $15 million a year away. Most of us don't have that. The IRS wants to keep track of what we're giving away. And that's more designed towards billionaires, because anything above $15 million that you pass with is going to be taxed at the federal estate tax rate, which is high. So they don't want billionaires giving away property while they're alive. You have the ability to gift $19,000 a year. If you gift more than 19, you have to file a gift tax return. You don't have to pay gift tax, but you have to file it. So if I give my son either my house or half my house, then I've gifted him more than $19,000. Technically, he's required to file a gift tax return. Also, God forbid he were to get divorced. If he gets divorced and I'm trying to sell my house, even if I'm a joint owner with him, now I need his ex-wife to sign the deed. So, yeah, right, that's not a good idea. The other way you can do it is you can maintain ownership of your property by transferring it to your children but maintaining a life estate. I don't like that option, but it can work. There are a lot of other ways to get around probate as opposed to a life estate. The problems that both Jane and I have experienced with life estates is, so somebody owns a house, they've given the property to their kids, they've maintained a life estate, which means they get to live there during their lifetime. Well, now I got to go into long-term care. I have to sell my house at some point while I'm in that process. Medicaid will say there's a value to my life estate. So if we go to sell the property, how do we determine what my value in that property is? Because I have to spend that portion of it down before I'm eligible for Medicaid. The issue is there are at least 3 different charts that tell us the value of life estates. Medicaid's chart says that I'll live forever, and so the value of my life estate is much higher than it really is. And then there are other actuarial tables that will say it's 45, but it's all based on life expectancy and those sort of things. So it's very difficult to figure out what the value of that life estate is. Yeah, Chris.
Can you terminate a life estate if the person that had the life estate no longer needs it?
Can you say that one more time?
Can you terminate a life estate from a property if the person that was residing in it no longer needs it?
If they're in that nursing home or live somewhere else right now?
So when you say, who do you mean by, who's going to terminate it? Are you talking about the life tenant?
I'll give you an example. I own a house in Northwood that my mother and father-in-law lived in, and we gave them life estate. My father-in-law has passed away. My mother-in-law now lives in, well, she doesn't even live in, she lives in a assisted living. Is there any benefit or ability for me to like remove that life estate while she's still alive? Or
Yeah.
wait until I have no intentions of selling, but I'm just asking the question
Yeah.
in general.
Yeah, and the issue really is how that life estate gets granted. So you can have life estates that get created through an estate plan. So I can say when I die, I'm going to leave my property to my son with a life estate to my wife. And if I do that in a will, I usually identify, what does that mean? Am I saying that she has the ability to use that property? Use, not reside. Does she have the ability to use that property during her lifetime? And if so, that means that life estate remains until she dies, okay? Or am I saying that she has the ability to reside in that property? And the problem is with most deeds, it'll say life use. And life use means she can move and she can rent that property and she can receive the rent from it. You see what I'm saying? Yeah. So we see that a lot with like farmland too. So people will leave farmland to somebody with life use to a spouse. And they're always generally they're trying to do that to avoid federal estate tax. But what does life use really mean? Life use means they can, because they're not living on the farm, this is tillable ground. They're receiving the income off of it.
So is that mucking things up for her in assisted living? Is she paying for assisted living right now, I'm assuming? So does that put a...
Yeah, I mean, there's a value. There's a value to what that life estate is. And you'd have to buy out that life estate. That's another good point. I don't know if that's where Jane was going with that. One of the issues that we see is, so a family's got 80 acres, and they want to try and preserve those 80 acres so that when mom goes into long-term care, Medicaid will pay the bill, but we're not going to lose the farm. That's not going to work. There is no scenario under which that works. What it can do, well, I shouldn't say that. There is one scenario, but that's super complicated and super expensive. But we have mom and all the kids, and the kids are like, we don't want to have to sell this land. Okay, well, if you don't want to have to sell the land, what you have to do is you have to buy out mom's life estate. And so that's when those actuarial tables versus the Medicaid tables come into play, because Medicaid ultimately has to approve this. And so which number are you going to use? Are you going to use it's 5% of the full value, or Medicaid's, it's 50% of the full value? Well, of course, Medicaid wants it to be 50% of the full value so that the kids have to pay mom, on 80 acres, $1.2, $1.3 million. So the kids have to come up with $700,000 in order to buy mom out. And what I find is that people hear this stuff through social media, they go to an attorney and they say, this is what I want you to do for me. And some attorneys aren't warning people or asking the right questions. And then we get stuck in scenarios where mom's got a life estate on property that's worth $1.5 million. She can't get eligible for Medicaid because the kids can't pay her out. They can't buy her share out. Now, if they'd have known this in advance, I'm not sure there's anything I really could have done to save them. The only thing I will say is that, where mom owned $1.4 million before, that if she went into long-term care, she'd have to spend all that down before she'd qualify. Now we've reduced it. So it's only 25% or 30% of the full value. The better plan with that 80 acres or other investments is to try and figure out a way where we've got enough income flow so it will pay for mom's care as opposed to having to sell that asset. That's the better approach. So, and we'll talk about it right now. This is the more complicated. There is one way to do it. If you put your property into an irrevocable trust, which is a very niche area, it costs you about 15 grand. If you put your property into an irrevocable trust, then there is a way to avoid that being counted as a Medicaid asset. But you have to cut all ties to it, which is really no different than you giving it away. And it's got to be more than 5 years before you apply for Medicaid. So if I have 80 acres, I can give it to Jack. I could do it right now. If I got 80 acres, I could give it to Jack right now. The problem, and then wait 5 years, apply for Medicaid, and then Medicaid will pay my bill because they can't claw back more than those 5 years. The problem is when I did that, Jack just took my basis. So if I paid $2,000 an acre for that property and it's now worth 12, that's a big problem for him. Now, if he's going to keep it his whole life and then give it to his kids, then it's not a problem because we'll never have to recalculate that basis until he dies and his kids receive it. But I also can't receive an income off of it either, which is usually where people are like, I don't like that idea. I have to give the property away to him, whether it's to him or it's to this irrevocable trust. So I can create an irrevocable trust, I can gift the property to the irrevocable trust, but I can't retain any income off of it, which is kind of a deal breaker most of the time.
And the irrevocable trust is what it says it is. I mean,
Can't be changed, you can't add to it, you can't pull out of it, you can't do anything. And the income has to go to some other beneficiary. So I could put it into an irrevocable trust, have it paid to Jack, and then Jack could pay me $19,000 a year because that falls within the gift tax exclusion. And that's how people do it, is they'll put it into an irrevocable trust, give it to the kids, and then there's an agreement between the kids and mom and dad that they're going to pay, each of them is going to pay mom $19,000 a year from whatever rent it produces. But then mom's got income now, and so then she might be disqualified for Medicaid. So
why is the cost of the irrevocable trust so high?
because people will pay it.
Let's see.
What was your question?
He wants to know why the cost is so high.
Why is the cost of an irrevocable trust so high?
why
Yeah,
would anybody want an irrevocable trust? Just because then they can't come after that?
Yeah, so they can try and preserve the family asset. There's a lot of liability, so I won't do it. One, I'm not quite sure it's going to work. Everybody says, well, my neighbor did it. Well, is your neighbor alive? Well, yeah. Well, then we don't know if it works. We're not, is your neighbor in long-term care? No. You haven't proven anything yet. You can prove that you can put it in an irrevocable trust, but we're not going to know if it's going to work until somebody dies, Medicaid tries to make a claim, and they're successful in defending that claim. I'm not willing to do it because there's too much liability that goes along with being wrong in that scenario. So I'll let the other guys do it, and that's what the other guys are charging.
One thing that we kind of talked, or that you talked about was, Medicaid's patched all these loopholes.
Yeah.
It's fairly recent. I mean,
Well, it's 1996. So in 1996, you actually could transfer property to a trust. And if you did that, you could still retain the income off of it and qualify for Medicaid. But then when Medicaid started getting hammered for that, then they closed up that loophole. And they said there can't be any connection to the property or the income stream, otherwise it's an asset that can be used for Medicaid reimbursement.
So then all the brainiac lawyers here and there and here and where started then writing IRS code into these trusts.
Yep.
And they say, this is what a connection means. I don't have that connection. So to write one of these trusts, you have to know all the ins and outs of IRS code. You have to know all the ins and outs of property ownership. So, I mean, I don't know anybody closer than Des Moines who doesn't. And I think that's largely the reason.
Yeah, I mean, there's a couple guys in Des Moines that do it. I think there's a guy in Dubuque that does it. And that's what I'm told is 15 grand to do those. Yeah.
Okay, you talk about it, irrevocable
Trust.
Is that the same as a probate or a trust?
It's the same as a trust.
All right.
So the trust that I'm talking about, like what you're referring to there, is my probate chart. Yeah, so when we started, we talked about different ways to transfer property: ownership, through an estate, and through a trust. A trust that I'm talking about is a revocable trust. So I have a trust, my wife and I have a trust. All of our property is in our trust. The idea there is that if I die first, nothing's going to change because she's a joint owner. When she passes away, the trust will then become irrevocable. Up to that point, we can add property to it, we can take property out of it, we can revoke the trust, we can do anything we want with it. The benefit of it is at our death, Jack's not going to have to probate it. He's the successor trustee, so he will step in, he'll transfer the assets to himself, and then the trust will shut down. He won't have to pay 2% attorney's fees, he won't have to pay 0.6% in court costs. And that's a big deal if you've got somebody that has, say, 80 acres and we're talking about $1 million+. That's $20,000 in attorney's fees.
So it's better to have a trust will rather than a probate?
Trust, so the will is the probate portion of it. So is it better to have a trust? You will reduce attorney's fees and court costs on the back end when you pass away. It is more expensive on the front end. So $2,500 is probably what you're looking for a revocable trust versus $500 for a will. But then when the trust is administered, it's not probated, then the attorney charges you by the hour. They don't charge you a flat percentage. So we see that a lot with people that have farmland, largely because of just enormous attorney's fees and court costs that go along with that just by code.
I'll kind of draw what we're talking about back to the slides. I'm not married to these slides. I'll just kind of control it a little bit. Because kind of what we're talking about, at least what I'm picking up on and what a lot of our appointments, what we talk about, is when people have, large volumes of assets. But I try and convince people my age at least. I say when I first day at the job, I was writing my own will. And I think that was important because a lot of these reasons, whether you have millions of dollars or whether you had $7 in your bank account like I did, it's still important because you get to control all these things. So for example, if I didn't have a will at the time, and now I'm married, but at the time it was just my parents. So Iowa code says where your property goes if you don't have a will. So say for example, I didn't have a will at the time, my property would have gone to my parents. Well, what if parents are separated? Or what if you think one of them can take care of this stuff and one of them can't? Because the Iowa court, if you don't have documents that say what you want to happen, who you want it to go to, who you want to look out for it, Iowa code has already decided that for you. And Iowa code makes that decision based on rainbows and sunshine, perfectly happy family. They say everything to the spouse. If not the spouse, then the kids.
And if there are no kids, then it goes up.
And then back down the family tree. Well, that's how people end up with, my third cousin left me an 18th of their estate. Well, it's because they didn't have a will, and then all of a sudden it just narrowly ends up there. So if you ever want to avoid something like that, and for me, part of it is, I want to control who's going to take care of this stuff. Dad would be better at this. He does this stuff every day. I don't want my mom to have that burden. So all I have to do is just have a will that says my dad's my executor. Because if I didn't have a will, the court's going to say it's both of them, or either of them.
Well,
or
what
they
the-
get to decide.
Yeah, what the court's going to say there actually is if there's no will, somebody has to apply to be the administrator. And whoever the beneficiaries are, they have to consent to it. And if they don't all consent to it, then the court has to decide. That sounds just like a recipe for disaster. The other thing, like Jack was kind of talking about, is how everything goes to your spouse first by code, even if you don't have a will. Spouse first, then your kids. If you don't have any kids, then it goes back up the tree to your parents. And then if your parents are deceased, then it goes siblings. So I get this question a lot. I think I've done a good job for somebody. I've said, okay, everything's to your spouse, and if your spouse and your kids, and their lineal descendants, blah, blah, blah. And they come up with the question, what happens if we all get killed in a car accident? Well, it's going to go to your siblings. Well, they're passed, so it's going to go to your nieces and nephews. I don't want them having the money for whatever reason, right? Well, there is a likelihood that that can happen, and we do travel together a lot. So you get to decide where it goes if we have a written document. If you don't have a written document, this is where it's going to go. Did I leave any question unanswered? Okay. Oh, yeah, and this kind of gets into it too. Guardians for minors. So I learned at one point, and I don't follow this, but I learned at one point, if we had clients and they were husband and wife, we essentially just said, a will is fine for you, and when the first of you passes away, then we can put you into a trust if that's what you want in order to avoid probate fees. But what I found is that oftentimes when that happened, when the first passes away, the surviving spouse is in their 90s. And the last thing that they want to do is try and figure out how to get themselves in a trust at that point. So I don't buy into that philosophy that it's a good idea to wait until the first passes away before before the surviving spouse goes into a trust. But the other thing is, what about younger people? Like they're 30 years old and they have kids and they don't have an estate plan at all. Well, who's going to take care of your kids if something happens to both of you? And if something happens to both of you, what are we going to do with the money that's going to your minor children? If they're under age 18 and they're receiving a share that's above $50,000, a conservatorship has to be opened. We don't want that. So what we can do is we can create a will that not only provides who the guardians are for the minor children, but we can also put a trust inside the will. And the trust doesn't do anything until it's called upon to act. It just sits there until then. But when it is called upon to act, it holds the asset. You decide who the trustees are. Those are the people that are going to watch the money for your children until they reach a particular age. 18 is just the base. And my wife would say that 55 isn't old enough to handle money.
I guess I have a question for all you guys too. You guys, if you've made your planning, you made your estate plan, have you talked to your family, your kids? Have you talked to beneficiaries about the responsibility and what's happening? And so I kind of challenge you guys to that too.
Yeah, there are some people that really shouldn't be executors. Yeah, Chris.
If I'm doing a will and I want, let's see, how is this, I wanted to say this. If my husband has passed and I would pass and I wanted to have a large portion of it to go to my son and then a portion of it to go to each of my grandchildren, and if they are not 18 yet, do I have to put their portion into a trust?
What I would do is, there's different ways you can do it. If you're going to do a will, you have a will, and inside that will you have a trust. And that trust says that you're going to give 50% to your son and 50% to your grandchildren to be divided equally, held in trust until they turn age 25. And then you're going to name who the trustee is. That's all you're going to do at this point. When you pass away, then that trust pops into action. And whoever the trustee is, then they'll take that asset from the executor, from the estate, and they'll open up a trust account with a bank. They'll act as trustee, and then they'll invest the money or do whatever they need to do, and they'll pay it out from there. That brings us to an interesting point about payable on death beneficiaries too. So you can avoid a lot of probate by using payable on death beneficiary designations for assets that can use that, like say an IRA or a certificate of deposit. Even checking accounts can have payable on death beneficiaries. But for example, if you say in that payable on death beneficiary to my son, 50% to my son, 50% to his lineal descendants, it can't comprehend what that means, so it's going to just pay that money to the kids. The problem is the kids can't receive it, so then somebody has to open a conservatorship in order to receive those funds. Now what you can do is you can have a will that has a trust inside of it for your kids, and we'll just call it the Krista Guthrie Family Trust. And then you can name that as your beneficiary on your POD. So you can have 50% go to your son, 50% go to your family trust, even though that trust doesn't yet exist. And so when something would happen to you and that trust pops into action, that 50% from the POD gets paid to that trust.
So like if one of them were then to be over 18 and one is still under, it would only be for the one.
It depends on how the trust document is written.
Because you can do it either way.
You can do it either way. So the way I do it, I don't like this, let's wait until everybody turns age 25 before we're releasing any funds.
So would it be better to split it and say portion to each grandchildren, say like 50, 25, and 25, and then whoever's not?
You'd have to have separate individual trusts for each of those. So if you're trying to, first of all, if you're trying to do it on your own, I recommend against it. But yeah, don't pull documents off of the internet, and yeah, don't do that. But so what I do is I have a trust provision that essentially says 50% to the lineal descendants of your son to be held in trust until age 25. And then I say that the trustee is authorized to divide those accounts into separate FBO accounts for the benefit of. And so when the trustee receives them, then they can place them into individual trust accounts for each of the kids. And then once that child reaches that age, it gets distributed to them. Instead of naming a trust for each individual one, I just do one family trust, but give the trustee the discretion to divide it.
And who would the trustee be?
Whoever you name.
And would it, so like if my son were to be the executor, could it be him?
It could be him, but there's also the possibility that if something were to happen to him and his share goes to his children, he's not going to be around for that. So if you're going to name him as the trustee, that's fine, but you better have a backup. Yeah. Or you can have a bank will charge for it, but you can name who it is.
I have a question. If your children pass away and you have stepchildren, grandchildren, how do they divide your money to them? Does it go just to
Say that you have.
All right.
You're just saying that essentially a share is going to, well, in order for a share to go to.
Or does it just go to the two? I have two family grandchildren and 3 step-grandchildren.
Never been adopted by.
No.
So if they haven't been adopted, if your will says to my children, and if my children fail to survive, then to their lineal descendants, it won't go to the stepchildren at all.
Won't.
Not unless your attorney is specifically told that that's what you want. And then what we do is we say, for purposes of lineal descendants, they will include my step-grandchildren X and Y.
Okay, so you have to have that.
You have to have it in there, otherwise they're not going to get it.
Wait for a lady with the microphone.
Thank you.
So we have a will, we have an executor named. Our executor is one of our adult children. We die. What does that executor do? What's the next steps?
Call the attorney, one. Can't get anything done without an attorney. And then this is what happens, this is the process that we go through. So we file the will with the clerk of court. So we meet with the executor, and essentially there's a questionnaire that I need the death certificate, I need last year's tax returns, I need a list of all the assets. And then we file the will with the clerk, and we ask that your son be appointed as the executor. The court approves that, enters an order that says your son is the executor, and then they issue letters of appointment. And that letter of appointment is what everybody is going to want to see before anyone will even talk to him. So if he tries to go to the bank to liquidate your account and put it into an estate account so we can pay bills, they're not going to let him do that unless he has the letters of appointment. The estate becomes a taxable entity at that point also, so we have to apply for a tax ID number, an EIN number. So then the executor takes the letters of appointment and the EIN number, and they go to a bank and they open up an account. And then they take all of your assets, checking accounts, savings accounts, CDs, they cash them out, they put them into that estate account. Any assets that have payable on death beneficiaries, the beneficiaries have to request the claim forms to get those payments.
Because that doesn't go through the will.
Because it doesn't go through the estate, which
So
is another
that's-
good point too.
that one.
Make sure I don't forget about that.
Yep.
And then the attorney drafts all the legal documents. So you got to file a report and inventory. The report and inventory tells the world what you owned when you died, and it's also used to calculate attorney's fees and court costs. We request date of death values. We have to publish notice in the paper for 2 consecutive weeks. Then we got a 4-month creditor period. We can't make any distributions during that 4-month period. We have to wait to see if the funeral home files a claim, or medical providers file a claim, or if you didn't pay for your Alliant bill or whatever. We got to get all those claims paid.
But if they had I don't mean to muck it up, but if they had a property during that time, they could still sell that property, or do they have to wait till after that 4 months to be able to?
It's a good question. They can sell it during that time period, and I would prefer that they do, to we don't need to continue to pay Alliant and water bills. So the sooner we can get that property sold, the better. They have the ability to sell it. The proceeds have to go into the estate account. Everything that you owned at your death has to be liquidated and put into that account or transferred to the beneficiaries. After that 4-month creditor period is up, then we file a tax return. Once the Department of Revenue says we've done it correctly, then we can make a distribution out to the beneficiaries. So the executor's responsibility is largely to do the legwork. So I'll get the date of death values, and I'll tell you, he had an account at First Citizens Bank, and he had an account at NSB, and then the executor will take the letters of appointment and go and get that check and deposit it into the estate account, and then confer with me for payment of bills, because some bills don't need to be paid and some bills do have to be paid. And then once we get past that creditor period, then we can do the tax return and make the distribution out to people.
Can I ask a question?
Sounds to me like the best answer is to not to die.
So,
If that
When
were
you
an
figure out
option,
that one,
so
let me know.
I see this a lot of times where the people are older, we sell their property, and they haven't paid taxes for years. So then they get that EIN number, we sell the property, that value is there. You have to file taxes. Am I asking that correctly?
well, I'm not sure what your issue with that is, but I'll share a nightmare I had, and then we'll go from there.
I don't have any issues,
Okay.
but when people say to me, well, why would they have to report that to the IRS? They haven't paid taxes for years.
Oh, okay, I thought you meant they hadn't paid taxes, but they were due.
No.
No, you're saying they've never paid taxes.
They haven't paid taxes for years because they didn't have enough income for it.
Well, the answer to that is it isn't them that's filing the tax return, it's the estate.
State.
Yeah, so an individual return is a 1040, an estate return is a 1041. So an estate's a taxable entity. We don't ever pay tax. An estate doesn't pay tax. An estate is a pass-through entity, just like a business. But we still have to file a tax return. And what happens is the beneficiaries either receive the income on a K-1 or they receive the deductions on a K-1. So if you have a house, let's say the only asset you had was a house, and you sold it. You had to pay me attorney's fees to probate. You had to pay realtor fees, commissions, closing costs, transfer documents. You had to pay to have a tax return. Property taxes.
Funeral bill,
Funeral bill.
utilities.
No, utilities we don't
Not
get to
from an estate?
deduct, no. Court costs. So all those things are deductions that as you as a beneficiary wouldn't be able to receive just by yourself. But there is a way that we can pass those deductions through to you. And the way we do that is we file a 1041 tax return, and it passes all the deductions through to the beneficiaries. So even if there wasn't any income, because the house is not going to be, if the house, there's no capital gains because we got to step up in basis. Even if mom bought that house for $20,000 and we sold it for $120,000, there's no capital gains. So there's no income. And if that was the only asset, there isn't any income that's going to be reported on that tax return. But you also would have lost all the deductions too. We file that tax return, we get the deductions. The state can't use those deductions because there's no income. So it passes the deductions through to the beneficiaries, and they can use them individually on their own return. And sometimes that's a big number. When we've passed out deductions of $10,000, $12,000 that people get to use on their own personal return.
Chuck, did you have a question?
Yeah, I've got a lot of questions.
What's that? Jenna's
You
cute,
sort of
though.
alluded to a while ago, get the right person to be your,
Executor?
thank you. How would you define that? I mean, I think a lot of people will go to just family members and that sort of thing. Are they the best choice? What kind of person should they be or not be based on that?
Sure. Well, I think, so it's always nice to have somebody who, what I wish is I wish that the courts would allow us to be the executor because we could get it done because we know what we're doing, but they won't let us do that without posting a bond. I want somebody who is responsive. So if I call, I need them to answer the phone. If I send them a letter, I need them to respond. Assets need to be liquidated. So I need somebody who has the time and the motivation to get that done. I, of course, need somebody who's honest. If we're not honest, that's going to be a problem. But I think the biggest problem, I need someone who can make decisions. So if we have somebody who just can't seem to make decisions, we're going to have a problem. I just know we're going to have a problem. You know the people in your life that you would say, I want this person to handle my checking account if I can't. That's the person I want to be the executor. Yeah. So it's usually, the reason that estates take so long other than attorneys who don't get their work done is executors who don't get their work done. And the selling of the house is the primary issue. And a lot of that can have to do not just with the executor, but how much stuff does mom or dad have in the house?
Is there
Yeah.
a time limit on
3 years.
3 years to close an estate?
We have 3 years to close an estate, but I get my estates done in nine months to a year.
Is there an advantage or a disadvantage if I have my son as the executor and he lives in Denver? Is that a problem?
I guess it kind of depends upon your assets. So, we live in a digital world and a lot of stuff can get done. I've got executors in California, in the state of Washington, all over the place. And there are good ones who can get stuff done. It's as easy as a call to these guys to get the property listed for sale. And if there's stuff in the property and they're on the East Coast or the West Coast, it depends on how much they are interested in being involved in the process of moving stuff out, or can we just pay somebody, or can we just auction the stuff off? So I don't think it matters that much. I wouldn't pick somebody that were close just because they were close if there was somebody that was a little bit farther away that you knew was a bit more responsible.
One thing we see a lot too is people want to name multiple people. So say, I got 5 kids, and we say, who do you want to be your executor? Oh, well, I love them all. So let's just have all 5 of them be the executor.
How many should you have?
Yeah, I don't mean to cut you off.
Yep.
Go ahead.
I will never let someone do more than 2.
So
If I've got
there's a
people with
difference
2
though between
kids-
financial and medical.
I'm even talking about executor.
Oh, executor?
Yeah.
Yeah. So I think the way that this is just my perception, and I don't mean to be stereotypical here, but Mama Bear always seems to want to make sure that everybody is treated equal, and Papa Bear doesn't always seem to care that much about that. So Mom wants to treat all of her kids equally, and so she wants to name all 6 of her kids as executor. Like, I'm not having that. That's just not going to work. And the same with a medical power of attorney. I can have one medical power of attorney, and you can have as many backups as you want, but we're going to stair step them. You're going to have 1, and then 2, and then 3, and then 4. And you can do the same with executors. I'm fine with 1, and then 2, and then 3, and then 4. And I'm okay even with co-executors. I can live with that. Because you can give the kids, or if it's the kids, you can say, look, you're both named as executors. This will work a whole lot easier if one of you decline to act. If one of you decline to be the executor, you can be involved in the process, just don't be the executor. And a lot of times the kids will agree to that. Financial power of attorneys, so my financial power of attorneys, I have those effective immediately. I don't have effective on a finding of incapacity like a medical, which means that whoever you're naming as your agent, they can act right away if they have possession of that document, which can be a good thing or can be a bad thing. So I have my wife and my son named as co-agents with either one of them authorized to act. They don't both have to agree. Any one of them can do it. What I've not done is I've not given them a copy of it. And it isn't because I don't trust them. It's so that I can use this and tell my clients this is what I do. So I have a safe, and in my safe, are my documents. And Jack knows the combination to get into my safe. But he's going to have to sneak past me before he does it. And if he has possession of the document, then he can use it. But if he doesn't have possession of the document, even though I've named him, he can't use it. Why do I make it on a immediate versus a finding of incapacity? Because, and I'll just use Mercy, Mercy is real quick to tell me that somebody can't make their own medical decisions, but they won't tell me that somebody can't make their financial decisions without running that decision through their legal counsel and neuropsych testing, which is about 6 to 9 months out. And I don't have 6 to 9 months to get bills paid. So whoever you name, you got to trust. Does that answer the question?
That was
More
good.
than answer it?
Yeah.
To
Yeah.
tie it to your question, though, a little bit, is if you've got this plethora of people to pick from, and I love them all equally, maybe the person to pick is the one who's going to ask all 5.
That's true. I agree with that. Especially with medical stuff, too, because we get that all the time. We get a lot of pushback. I want to name both son and daughter. And I'm like, well, which one? I don't know why you want to do that, because if they both disagree, then we're not getting anywhere. And somebody is going to be upset with me. I guarantee you that. Why not pick the one? Well, because this is what they say. When I say don't do 2, just do 1 and have the other. Well, they get along great. They communicate so well. Well, if they do, then just name 1, and we'll see if what you think is true, and they actually do communicate. Because if they communicate, then it's not going to matter. What was I? Oh, well, one thing here. Okay, so what a will doesn't control. When we talk about trying to avoid probate, real estate is the one that kind of gets us stuck, because most everything else that you own can have a payable on death beneficiary. I want to say this before I forget. Don't include in your will assets that already have payable on death beneficiaries on it, because the will's not going to control. The beneficiary designation is going to control. So if you have a checking account that has your child as your beneficiary, don't then put in your will that your bank account goes to your wife or whoever, because that's not what's going to happen. It's going to go according to the beneficiary designation.
And the way that we write wills, at least, I can't speak for every attorney, but we try and write wills so that you don't just have to come in to fix little nitpicks here and there. So we don't say, for example, I want this checking account at Clear Lake Bank and Trust to go to my daughter. We say, take what I have and split it in these percentages. Because if for whatever reason you close that account and you reopen it and it has a different account number, well, then everyone's going to be kind of confused.
Yep.
So we don't want you to have to come in just because your assets change. So we don't list in our wills, my house at 123 Boulevard goes to my son, because what if I move? What if I sell that house, I buy a condo, it's a different address? Well, then now I have to go back in and change my will to update the address so that people don't get confused. So we don't do that. We
Yep.
write our wills so that they're like, I don't know, I don't think generic's the right word, but they're overarching. They don't give this to this person and this to this person unless you want to do that.
And
for
we
any
talk
reason.
in the appointment about, because we ask them about assets all the time, and I say, okay, well, do you have payable on death beneficiaries, or who's the owner of this account? Those things are going to pass outside. I mean, in reality, you could avoid almost every asset going through probate by owning it jointly with rights of survivorship, or having your accounts payable on death or transfer on death. Almost all retirement accounts require a beneficiary designation. Just make sure you have it done. And life insurance, that always has a payable on death. So then if those are the only assets you had plus a house, the only asset that's actually going through probate is your house. And so if you're paying 2% in attorney's fees or 0.6% in court costs, if your house is only worth $200,000, that's all you're losing, and that really isn't that much. So a lot of times the only asset, we can get it down to a point where the only asset that's transferring through probate is your house. And then we start talking about things, well, how about a life estate? Or how about, putting my son on the property, et cetera. And I'm like, why don't you just pay the attorney's fees and just let it go through probate the way that it's supposed to, as opposed to all the other things that can come along with it. And some people might think I've got some incentive to say, why don't you just pay attorney's fees? And I probably do, but I think it's true, because if you look at all the problems that can come by putting your kid on the property just to avoid probate, I don't think it's worth it. And then so this kind of also gets us to like a trust too. So we don't list where assets go in a will by specifically. We'll just say, everything to my wife fails to survive, and then to my son or whatever. If I have a specific piece of property I want to go to somebody, I might include that, or personal property or whatever. A trust is very similar from the standpoint that we don't get very specific with where it goes, but what's critical there is the change in ownership. So when I opened up a trust, I owned it. I owned my assets before the trust opened. So my wife and I owned our property. We have some business, we have some LLCs that have membership units. I've got a retirement account, we've got some CDs, we've got some cars, things like that, right? So in order for my trust to really direct where my property goes, my trust has to own those assets. So we have to transfer the title of my house from me individually to me as trustee of my trust. We have to transfer my membership units in my LLCs to my trust, so that my trust owns those LLC units. If I have a promissory note where somebody owes me money, I have to assign the ownership of that promissory note to my trust, so that my trust owns it. And then, okay, well, what should I do with my IRA? Well, trust can't own an IRA. Okay, well then maybe I should make my trust the beneficiary of my IRA. Don't do that, because if you do that, all of the income from your IRA, when you pass, is going to get recognized immediately. So, and you're not going to give your beneficiaries the opportunity to do a 10-year rollover IRA. So just keep individual designations on that. Now there are other assets that you could have. You could either have you could have your bank account owned by your trust. That's one way to do it. Another way to do it is have the beneficiary of your account be your trust. You can still own it individually, and then when you die, your beneficiary is your trust. So it gets paid to your trust, and then it gets distributed out according to the terms of your trust. So we're not identifying specific assets as where they're going in the trust. We're just changing the ownership, so the trust decides where it goes. Does that make any sense at all? Okay, all right.
So I have a question.
Here she comes.
So in regards to your POD and TOD bank accounts, so let's say that a person owns nothing, and puts all of their resources in bank accounts and savings account and investments, and everything is arranged so that on death, everything is distributed. So there's no need for probate or anything like that.
As long as you don't have real estate.
How do the debt, I mean, if
How
there
the
is
debts
debt-
get paid?
Yeah.
Yeah. Well, so I'm not sure that I necessarily know the complete answer to that because I wouldn't be involved. So what can happen is somebody can have a will but not have any assets that are anything other than payable on death and transfer on death. So if that's the case, you don't have any real estate, you got a will, an original will. If you pass away, you've got a beneficiary or an executor named. Your executor comes to me and says, what do I need to do? I say, well, we need to file the will, and we need to tell the clerk of court we're not going to probate it, we're not going to administer it. We publish notice for 2 consecutive weeks, and then the creditor period starts. So the creditors, it's published in the paper, they file claims in that estate. And then I, as the attorney for the estate, write a letter to them and say, there aren't any assets. And then they go away. And that's the benefit of that creditor period and why you file a will, why you publish notice, why you set up that creditor period. Because if you don't do any of that and everything gets payable on death to the beneficiaries, I think that those creditors could come after the beneficiaries. Medicaid's one of them. So like that might be the hot topic for some people is like, okay, well, if I don't have real estate, I mean, I don't know that there'd be a Medicaid claim. I think maybe if you had a spouse that was on Medicaid and they died, that Medicaid claim still ends up being a claim for the surviving spouse. And then the spouse sells their home, they take all of their assets, they convert it into cash. They die, all of the benefits were payable on death to the kids. And the kids are like, whoo, we don't have to pay Medicaid back. That's not going to work. Medicaid's going to send them a letter saying, you owe us money. They don't care if it got paid to them by way of payable on death or transfer on death. That also applies with inheritance. Well, we don't have inheritance tax anymore, but it used to apply with inheritance tax. So those big creditors, they still have a way to get to it. I'm not quite sure what the smaller creditors would do, but the best thing is for your executor to file the will, publish notice for 2 consecutive weeks, wait for that creditor period. When the claims come in, have the attorney deny it because the estate really doesn't have anything. It got transferred outside. The only thing that the attorney will have to do is if there is a Medicaid claim, they're going to have to help the beneficiaries reimburse Medicaid for that.
Thank you.
Yeah, sorry, Krista, yeah.
How do you transfer a vehicle if you don't go through?
What was the question?
How do you transfer a vehicle on death? Like, you don't have a house maybe, but you have a vehicle? You have to go through probate.
Well, you have the ability to use what's called a small estate affidavit. So if the only asset you have is non-real estate and it's less than $50,000 and all creditor claims have been paid, your next of kin can take an affidavit of small estate distribution to your bank, to the treasurer, whoever has the asset, show them your death certificate, show them that you're next of kin, and they'll transfer title as long as the asset is below $50,000. Now, anymore, assets are getting to be more, cars, people are paying more than $50,000. Our treasurer's department will allow you to transfer title at death to the next of kin with just a proof of death. They won't require anything more than that. I'm not sure if they're relying upon that affidavit or not, but that's just in Cerro Gordo County because the other counties are all wonky. None of them are all the same on that.
We had a question over here.
I just want to make one comment about Medicaid, but then I have a question. My mother had been in the nursing home for quite some time, and my grandmother's estate came through with a very large check from her estate, happened to come the day before my mother died. And I did not know what to do with the check, so I went ahead and put it into her account that I had at the time. And
Her account?
her account that I had for, like, for her nursing home and whatever. But in the end, Medicaid came back, and I
Took it?
had to take all, they accounted for everything that she had, they had done for her, and the whole thing was used. I mean, they gave an accounting and everything. So they do come back. I mean, she had nothing, assets, whatever, but they do come back.
Yeah.
And I had no problem with it because they had taken very good care of my mother through the years. So.
And I don't want to give anybody an escape hatch, and I don't want Krista to feel bad about what she did, but I want to use this just as an example for a financial power of attorney also. One of the benefits of a financial power of attorney is you can give your agent the power to disclaim a gift. So it sounds like the timing probably wouldn't have worked very well here. I encourage my clients to give the power to refuse a gift to their agent. So in this scenario, if Krista would have been the agent and we would have had more time, Krista could have disclaimed that interest on behalf of your mother, on her mother. And if she would have disclaimed it, Medicaid would not have had a claim to it. And what would have happened is instead of going to your mother, if she disclaimed it, wherever the will said it goes in the event that your mom had predeceased, that's where the asset would have gone. So you can disclaim a gift in order for a Medicaid recipient not to receive it, and then Medicaid can't have a claim to it.
So where would it have gone?
Wherever the will directed that it goes. So whoever left that money to her, if it said your mother,
My grandmother.
yeah, so if it was your grandmother, if your grandmother said to my daughter, and if my daughter fails to survive, then to her lineal descendants, sorry. But that's another good reason to have a financial power of attorney. In fact, I use that power more than I use any other power.
See, I did have that, but my aunt and I were just scrambling. We didn't know what
Well,
to do.
it didn't have enough time probably to do anything there.
Okay. My other question was, you said something about there are some bills that we do pay and some we don't.
Mhm.
What bills do you not pay?
Well, so it depends on how the process works, but so if we have an actual probate with administration, we file the will, we put it in the paper for 2 consecutive weeks, that starts that 4-month creditor period. It gets published, and so if there are creditor claims, it gets submitted. If the creditor claims get submitted during that 4-month period, as long as we have sufficient assets, we normally pay those, as long as there's not statute of limitation problems or things like that. But if somebody doesn't file the claim within 4 months, they're out of luck. And so it's not unusual for me to get notifications from credit card companies for estates that I've had, and they haven't filed their claim. And sometimes it's even during the 4-month period, and they say, well, are you going to pay this? I said, no, I'm not going to pay it. You have to submit a claim. If you submit a claim, then I'll consider it. But until you submit a claim, I'm not going to do it. And then I get a call 2 months later, and it's from the same people. Have you got our claim? No, I haven't got your claim. And your 4-month creditor period is up. So I can't pay it. I mean, I have to tell the executor. What I tell the executor is, you can pay it if you want to, but you're under no legal obligation to do it. If people file a claim and you don't think that they are the right to have reimbursement, then the attorney disclaims it. They file a dispute, and then if that other party wants to be heard in court, they have the opportunity to do it. And if they don't ask for it, then they don't get it. The priority claims are Medicaid, funeral expenses, expenses of last illness, attorney's fees, court costs, and tax prep. Did I miss anything? Okay. So those are the ones that have to get paid. Yeah.
Well, I know we talked about debt and assets and stuff like that, but we never talked about wishes. Do wills control your wishes? I can give you a scenario.
Well, I mean, I would say the answer is yes, but go ahead.
Okay. Well, should I outlive my wife? Hopefully, if I don't, the wishes are taken care of. But should I outlive them?
Oh, sure.
My daughter has determined that I need a funeral, I need a casket, I need a burial plot. I don't want. I want to be burnt, put on a garden or something. But
Yep.
what?
Here.
So that's not a will.
Okay, what is,
It's what's called a declaration of designee. I don't know if this document actually really did exist, but I would say 5 years ago, the funeral homes came to me and said, we're having a real problem when somebody passes away, they don't have a spouse, and then we have one child that says burial and one child that says cremation. And we're having to go to court to get that decided. Can you do something for us? So we drafted a document that we call a declaration of designee.
It's like a third power of attorney, essentially.
And it names the person that you want to make the decisions for your funeral. And you can even express in there what you want. And that is controlling. Otherwise, it will go to next
Could
of
he
kin.
put the funeral home in charge of that?
You can also, yeah, well, you're talking about naming them as a designee? I don't know, I've never done that. You could obviously, pay
Because
and
it's obvious
prearrange
his daughter
too.
wants something that he doesn't want.
Well, but you can give them a copy, so you'd have to name somebody.
I could have you draw it up,
Yep,
and could I have you
yeah,
control?
yeah. There's no requirement for posting bond. I can't be an executor without having to post bond, but I can be an agent or a designee in that case. You can name anybody you want. And you can express your preference for your wishes. That's just a preference. The person you're naming is the person that you're going to have trust that they're going to do what you want.
So it's my understanding that you can prepay funeral expenses?
Yep.
With a funeral home also?
Yes.
So that all those arrangements would be taken care of?
Yep.
then?
Yep. You can prearrange it too if you want to pay for it in advance.
And then if you're looking at Medicaid or something like that, that's again, something that you can use your money to prepay all this stuff so they don't get it.
To spend it down, yeah,
Spend it
if you've got
down.
resources. You get that question, or I get that question a lot, when people are getting kind of close to that point of where they might be Medicaid eligible, but they have $10,000 left or something like that. Go out and prepay your funeral expenses, you can do that. But for you need to name the person that you trust to make the right decision for you.
Could it be somebody other than a family member?
It can be anybody.
It could be anybody, even your...
Yep, yep.
Question over here.
Just a very quick follow-up to prepaying for your funeral arrangements. One of my parents just passed away not a couple of months ago, and we had been told for years that everything was taken care of. We weren't, there was going to be nothing, and he was interred, but there were cemetery expenses.
Sure.
That added up to close to $15,000 that we weren't expecting for the preparation of the gravesite and all of the other various and sundry fees that the cemetery was going to charge, like $2,500 administration fee. So be aware.
Yep.
Or make sure that your descendants are aware that they're, that either all of that stuff has been taken care of or that they should go in prior to and double check. And apparently there's going to be another $15,000 for when my mother passes.
Yeah, it's a good point. Make sure that you know what your funeral arrangement payment covers.
I have two very quick, very general questions because I need to go. 25 years ago, when my mom redid her will after my dad passed away, was there such a thing as a financial power of attorney? Because I don't have that copy if there was such a thing.
Yeah, I don't know. So the financial power of attorney forms are actually promulgated by our legislature.
Okay.
So they're the ones who put it together. I know that there was one done in 2017, there was one done in 2013, there was one done in 2010. I'm not sure if I know prior to that, but there might not have been.
Okay, that was one question I had. And the second question, I need to ask.
So if the people that are leaving, if you win something, I'll get it to you. So, well.
She is very concerned that after she did that will, my fault that I moved 3 or 4 times, and my address is not the same on her will. Does that make any difference?
Doesn't make a difference.
Perfect. That's all I need to know.
But I would tell you this, so if I do your estate plan and you call me and you say, so-and-so's address has changed, do I need to change my documents? I'm going to say, does anything else need to be changed? And if you say, yeah, this needs to be changed and this needs to be changed, then we're doing it all.
Okay.
But if that's the only thing, we're not going to change it.
Perfect. Question.
I was previously married, had a son. She remarried. I don't know if I should say they or he adopted him, so they changed the last name. Does he have any effect on any of my, if I set up a will and stuff, can he come in and try and do anything to it?
So my experience is you need to be clear that there was a termination of parental rights and an adoption, because that's different than just a name change. I've seen all kinds of situations where the name is different, but they didn't actually go through the process of termination and adoption. They just did a name change. So if it's just a name change, then yes, he's still a lineal descendant. If parental rights were terminated voluntarily or involuntarily, and there was an adoption, he's no longer a lineal descendant.
Okay.
Which is very difficult for an attorney to figure out because those records are sealed. I can never get to those.
Okay. I think that was done in Worth County.
Now, if the easiest solution is just to intentionally exclude them in your will.
Okay. The second half of that question, if I have expenses, can they go to him to try and collect them?
No, they can, well,
Or is he insulated from it?
So if he's a beneficiary, if you have an estate and there are expenses in the estate's going to pay for those first before anything gets distributed out to a beneficiary.
Okay, he won't be named as a beneficiary.
If he's not named as a beneficiary, then your estate will have to handle whatever expenses, if they're priority expenses, if they're submitted within those 4 months. After that, their claims are cut off. And it's the estate that handles the payment of those expenses, not the beneficiaries. If there aren't sufficient assets to cover your expenses, they can't come after the beneficiaries for anything beyond that.
Moving ahead, I'm not married, but a gal and I live together,
Cohabitate.
whatever you want to call it. Does common law marriage enter into any of this, or?
It does, so Jack can probably help me a little bit with this, but you have to, I don't know that there's a time period, but 10 years, but you have to represent that you're husband and wife. And for example, tax returns, health insurance, social media posts, do you wear rings? Do you introduce this person as your spouse? If you don't, they're not common law. That doesn't prevent them from trying to assert that they're common law, but they'd have to establish that not only did you cohabitate for 10 years, but you also made representations that you were husband and wife. Otherwise, it's not. And if it is, then they're entitled to either 50% of your estate if you have other children, or they would be entitled to other children from another marriage.
I've got no problems leaving. I've got a house, there's a lot next to it. I don't have a savings account. I live on Social Security.
Mm-hmm.
That's all I've got.
Yep, so you got a house that would go through probate.
Yeah.
Yep.
But what I'm wondering is, can I leave it, I'm thinking about leaving it to her son, probably before I die.
You'd have to gift it to him, which kind of gets back to the question about putting somebody else on your deed. So they end up with your basis, become subject to the claims of your creditors. It's rental property subject to rental inspection, and it's not entitled to any type of homestead protection. Not a good idea.
That's what I want.
Yep.
Okay, we're gonna